Hello and good afternoon to all the participants and my co-panelists and speakers for this afternoon on this interesting webinar called GST Dilemma, Applicability on Grants. As the name suggests, there is a dilemma, there is a confusion whether GST is applicable on grants or not. And that is what we are going to unravel and discuss today afternoon for about 4:30 till about 4:30 p.m. So that's the time that we have. That's what has been planned for the day. And we have received an overwhelming response as always. There are close to 1,400 registrations that has been received. And as I speak, I see people are logging in. We are also live on Facebook. So those of you or those of them who are not able to log in can also watch us live on Facebook. It is presently live. Today I'm joined with three esteemed panelists. We are a team, as you all know, who have attended our webinars in the past on FCRA and income tax. So I have with me Dr. Sanjay Patra, who is the Executive Director of FMSF. Well, I don't think an introduction is necessary. He is quite well known in the civil society sector. He's a qualified chartered accountant, at the same time one of the leaders of the development sector and has been a leading voice. Then I have with me Mr. Suresh Kejriwal, a chartered accountant, a consultant and a very dear friend of ours, who is part of our think tank, an expert on laws, financial management aspects of development sector. And we are really happy that Mr. Kejriwal is with us. Then we have Dr. Manoj Fogla, a lawyer by profession, a chartered accountant, an author of several books, possibly the best legal mind in the country as far as non-profit laws are concerned. And today we are here, as I said, to discuss about GST with particular emphasis on applicability on grants. And let me tell it as a rider that we are not going to take up issues outside this ambit, which is defined in the brochure that was circulated, which is specifically on applicability on grants, because GST in itself is a large topic and we will not do justice in terms of handling it in an hour's time. This webinar was induced because of this advanced ruling that has come up from the Maharashtra Authority for Advanced Ruling, a particular case relating to Jaishankar Gramin Va Adivasi Vikas Sanstha, wherein as part of this advanced ruling, it was ruled that GST is applicable on grants, not on donation. So what does this ruling say? What is it all about? Does it have implication for NGOs, outside this particular organization or in Maharashtra, in rest of the India? So that is what we are going to discuss. Point by point, we are going to analyze this ruling and what it has to say and what our legal experts have to say about this ruling. So that is where we are in terms of the plan for the day. In terms of the flow, we will have a presentation by Mr. Kejriwal on this particular advanced ruling, what the ruling says, followed by a question and answer session with our legal experts. I would raise some questions based on the presentation Mr. Kejriwal is going to make, which would continue for about 30 minutes. And post that, I would also take up questions from the participants. Remember, when you write questions, please use the chat box instead of question answer box, because my team here is going to compile the questions and it is easier to do it in a chat box. So please don't share pleasantry message, even though they are welcome otherwise, but I would request not to use the chat box for sending pleasantry messages, but write your questions there, and specifically on the topic that I have shared, which is on applicability on grants, because outside this topic, we may not be able to take up questions. So that is the plan for the day. Before we begin, I would now like to invite Dr. Patra to give an overview of this particular issue, followed by the presentation from Mr. Kejriwal. So over to Dr. Patra.
Good afternoon, and it's our pleasure and a privilege to be inviting all of you for this webinar. Well, taxation has been a ticklish issue, be it direct taxes or indirect taxes, the GST, whether it is applicable, not applicable, all these things were once again stirred up with this advanced ruling that came in. And till then, when this came in, we have been flooded with questions and clarifications and what should be done, what not to be done, and so on. I think the advanced ruling again has made this whole issue wide open, and confusion in the minds of the civil society organizations, whether it would apply and whether CSR grants will be in it or not. Donations, what happens to donations? What happens to some tied up money, restricted grants, and so on? Because the GST law itself defines some of the charitable activity, and whether those charitable activity, if anyone receives any funds, whether that will be covered under GST or not, whether this will be a supply or not. There have been number of issues which have come up, and what we did was that with Dr. Fogla and Mr. Suresh Kejriwal, we came up with a publication of our standards norms, which I hope that all of you have received. If not, then you can also download from our website, fmsfindia.org, which somehow looks like this: GST on grants and donations. And there we have analyzed very clearly about its applicability. However, we also realized that it could be very technical in nature. And so we thought that we should follow it up with a webinar where we will be able to explain further and take up some of the practical issues and discuss it. So this is promising to be a very, very interesting time where we will analyze it from various angles and from practical issues, practical applicability. And that therefore, your questions are important to us, even though we will also have certain startup questions on which we are going to start the discussion. But before that, we'll also hear Mr. Suresh Kejriwal, as my colleague, Mr. Sandeep Sharma has outlined the day. So we are all here together as we are seeing more and more people joining in. It's over to Mr. Sandeep Sharma to take it forward.
Yeah, thank you, Dr. Patra. Well, without much ado, I would now request Mr. Suresh Kejriwal to present on this ruling. Please help us understand what it says.
Thank you, Sandeep ji, for inviting me. Thanks, Sanjay ji, for setting the tone for today's discussion. Before I start with my specific presentation, I would like to share with you that GST, applicability of GST to an NGO, to a charitable organization, is a very, very complicated issue. Mainly under the background that before GST, there was a Service Tax Act, and the Service Tax Act, the service was defined, services rendered by one person to another person for a consideration, without linking the same with business or charitable activity. And that's why under service tax, there was an exemption notification exempting all the charitable organization release activity not to be part of the service tax applicability. But under GST, though supply has been linked with the foreign furtherance of business, but at the same time, those exemption notifications have been included in the notification under GST, and thereby it gives an impression whether the charitable activity or release activity falls in first place under as a business activity, and then it becomes exempt because of the exempt notification. Again, under GST, business has been defined in a way that it takes away the basic characteristics of the business, like frequency of transactions, intent of profit motive. All these conditions, which is very much required to constitute a business, has taken away with. And then it creates a very, very complicated issue. Then there is no profit intent is required. There is no frequency of transactions required. Then how we can define whether our program activity funded by grant can self-constitute service as per the GST Act. Let me share my presentation.
Sureshji, there is a request from the participants to go a bit slow. If I may request you to, yeah, thank you very much.
मेरा presentation है कि नहीं?
Yes, you can go to the first slide maybe.
Suresh ji, you are muted. Please unmute yourself.
Sorry. So let me start with the concept and applicability. When a grant can be considered to be a
You are on mute. You are on mute. Please unmute yourself, Suresh ji. Suresh ji, please unmute yourself.
Okay. So when the grant can be considered to be a supply, I understand this requires 3 tests. First test is that it must be covered within the definition of a scope of supply. And scope of supply says there is a supply of goods and services and and it is for a consideration and it is in the course of furtherance of business. So until and unless the supply constitutes these 3 elements, there has to be supply of goods and services, it has to be for a consideration, and it has to be in the course or furtherance of business, then the said supply can constitute a scope of supply under the GST Act. But even it is supply, now second test is whether we have to find out whether it is a taxable supply or exempt supplies, and for that we go to the exemption notification, and if that supply is exempt through exempt notification, then even though it is a supply, it will not constitute a taxable supply. And even if we fail in the test of exemption notification, then we go to the third test, and that is we have to find out whether the aggregate taxable aggregate turnover is crossing a specified limit. So basically, first test is to understand whether the goods and services which are supplied for a consideration, and those are in the course and furtherance of business. If we satisfy this test, then we go to the exemption notification and we find our services covers under exempt notification. Again, we are out from the GST purview. And if we find we are not covered under exempt notification, then we go to the third test and we have to find whether the aggregate turnover exceeds 40 lakhs or 20 lakhs as the case may be. And then only the GST application start. Now, what shall we mean by supply of goods and services? Suppose you are receiving a grant as a voluntary contribution or as a corpus fund. So there is no condition to supply any services. There is no program element in it. So when the grant agreement is without mentioning any supply or any implementation of the program, it is for corpus or it is for as a voluntary contribution. So this agreement cannot constitute an agreement for supply of goods and services. And that's why I understand any agreement, any grant agreement which are voluntary with voluntary contribution or towards corpus will not constitute, will not satisfy the first test itself. Again, providing of goods and services presupposes 2 parties, one person providing the services and another person receiving the services. Again, we find in an NGO, when we plan the program, in certain cases, there is no direct beneficiaries. Like for a greening program, we put some plantation, do plantation in the government land, so that it is going to benefit at a later stage and to the society at large. So here in this program, there is no direct beneficiaries who are going to benefit at that particular point of time. We understand the nature of program with no identified beneficiary may not come within the scope of supply of goods and services, as there is no clarity as to who are the service recipient. However, this issue is yet to put under legal scrutiny. The second important issue is consideration. When the grant will constitute consideration. We all know the GST is on the supply of goods and services, and it has nothing to do with the income side. However, when the grant agreement is drafted in such a way that it mandates or it requires this implementation of certain program or performing a certain task by the NGO, then that grant becomes a consideration because of the grant nature, grant agreement itself. So consideration has been defined under the GST Act, and which says that it is not required that the recipient of the service is required to pay the amount. The payment can be made by a third party. Meaning thereby, if the services are rendered to a beneficiary and the donor is paying you the money, then it can be constituted as a payment by a third party and satisfy the test of consideration. Secondly, the term consideration has been defined that it shall not include subsidy given by the central government or a state government. Now, again, the subsidy term is not defined. Basically, subsidy means the government is subsidizing the total cost of your organization, and the subsidy term is used basically in the profit motive organization, and the intent of the act is to exempt the subsidy part even for the profit making organizations. I understand then the grant received from central and state government to subsidize our program should also be outside the definition of consideration because of the specific use of the term subsidy in the definition of consideration. As per my understanding, grant should constitute consideration when the grant is linked with the services to be rendered and also with the beneficiaries. The linkage of grant resulting into some benefit of the organization. Suppose a grant agreement provides that they will cover all the cost of the delivery of the program to the specified beneficiary, and the organization will also get something in lieu of services rendered. Then I think the linkage of grant resulting into some benefit of the organization. Now, there are certain other grants which results into some benefit or services to the donor agencies. Suppose donor agency says that you have to train this 10 particular staff or 10 particular beneficiaries, or they are saying you have to do a research work and submit back to us. So all that will constitute a benefit and services to the donor, and this type of grant agreement may come under the purview of GST or the scope of supply. The third vital test is whether our supply of goods and services is for or in furtherance of business or not. Again, business has been defined as it includes any trade, commerce, manufacture, profession, vocation, adventure, wages, or activities ancillary to it. So basically, they are very specific that any trade, commerce, manufacture, profession, vocation, adventure, wager, or activity ancillary to it will constitute business. But again, I understand that when we implement the program, we are not falling under the category of trade or commerce or manufacture or profession or vocation or adventure or wager. And if our program activities don't fall under any of this specified category, I think we should be out from the definition of business. But again, this issue has not put under legal scrutiny, under debate even by the advanced ruling so far. Secondly, when a primary objective is to undertake charitable purposes, then incidental activities should also be for furtherance of charitable activity and cannot be said to be a cause for furtherance of business. Again, when an incidental activity is to support the exempt services under GST. Suppose for religious activity, there were exemption notification. And if we are undertaking any incidental activity to support that exempt services under GST, then at least I understand that incidental activity cannot be considered as a furtherance of business, because that can be only furtherance of a exempt services under GST. And it is also being held under the various court ruling, not under GST, but under income tax, that grant for specific purposes are legal obligation for the recipient organization and cannot form part of the income of the organization. And these are basically a legal obligation and doesn't constitute part of the income of the organization. All the above points are not subject to public scrutiny so far or subject to advanced ruling, and all the advanced rulings are based upon the premises that all the activities of NGO are covered under the scope of supply, as the word whether or not for profit motive is included while defining the term business. Now I will just go through what is this advanced ruling, which has created so much of debate under the NGO circle. Now the facts of the case as presented by the applicant. The applicant is a charitable trust registered under Maharashtra Public Charitable Trust Act 1950. The applicant is also registered under section 12AA of the Income Tax Act 1961. The applicant itself says that the trust undertakes supply of services to 50 orphan and homeless children by way of shelter, education, guidance, clothing, food, and health for the women and child welfare. That means here is the case where the applicant himself makes a petition that they are engaged in undertaking supply of services. Again, they also said they also render services to destitute women who are litigating divorce or homeless or the victim of domestic violence. And their major source of income is explained to be from the government of Maharashtra and also from the central government and other donations from the public. And there are three issues raised by the applicant. The first issue raised by the applicant is whether applicant is required to obtain registration under the Maharashtra Goods and Services Tax Act 2017. So first argument raised by the applicant whether they are required to obtain registration, without going to the argument whether their grant agreement constitute consideration or in the furtherance of business. The first argument was whether they are required to obtain registration under Maharashtra Goods and Services Tax Act 2017. And the second argument was if the answer to the above question is affirmative, if the department feels yes, they have to require to be registered, then whether applicants is liable to pay GST on the amount received in the form of donation and grant from various entities, including government and central government, state government. And third issue was if both the above issue is in affirmative, then they wanted to know the rate at which GST should be charged. And when they put up their case, they've given the following argument. In this case, the applicant has already accepted that they are engaged in supply of services, and therefore their main argument was that their services falls under the exemption notification because of their being a charitable entity, and that's why they have taken this plea. Though they are engaged in the supply of goods and services, but they are exempt to the exempt notification. Again, they are saying if they are not exempt, then whether the grant will not constitute consideration and not for the furtherance of business as a second argument. And the applicant also cited the definition of consideration, which doesn't include the subsidy from the state and central government, should not form part of the taxable supply, because the term consideration has been defined to exclude subsidy from the state and central government. And that's why the grant, they are basically receiving grant from the government, state government. So they have also taken this argument that then the subsidy is also in the form of grant is also in the form of subsidy. And that's why even if it is taxable, this should be reduced, the government grant should be reduced from the taxable value. And they have also cited the following two circulars and case law. The circular 2010 under the Service Tax Act, where it was opined that service tax is not eligible since donation or grant in aid is not linked to specific training and training. That means under service tax, the same issue has come up, and the department has given a circular that until and unless the grant in aid or donation is linked to a specific training or a training, up until then, it can't be covered under Service Tax Act. And again, there was a ruling of the Apex Court, which says only utilization of money for agreed purpose will not result in service provider and client relationship. A client must not only pay the expense of the services, but should also pay consideration or reward for the services to the service provider. Again, the Apex Court has said that it is to generate or to create a service provider and client relationship, the client has to be rewarded more than what he has incurred. Until unless that is happening, the agreement cannot constitute a service provider and client relationship for the purpose of indirect tax. The observation, what are the observation made by the Advanced Ruling Authority? Advanced Ruling Authority, they are saying that the services rendered by the applicant doesn't fall within the definition of charitable activities as per the exemption notification. We all know exempt notification, though covers charitable activity to be exempt, but charitable activity is defined very, very thinly. Very, very lesser activity comes under that GST notification, and that's why the GST appellate or Advanced Ruling Authority were of the opinion that specified activity as per the GST exemption notification are not the activity which that particular applicant is carrying on, and that's why they have ruled that they are not covered under that exempt notification. Again, the argument of the applicant that the consideration should not include the subsidy, they have simply, without analyzing, they have simply said the word used is subsidy and not grant, and therefore grant was supposed to be included in the consideration. Without going into any argument, they have gone into the term used in the consideration. So they are saying the term subsidy is used and not the grant, and here the case the applicant is receiving of grant, and that's why this consideration definition is not applicable on them. Again, they have not discussed the 2010 circular and the Apex Court judgment as cited by the applicant. Instead, they have referred a 2019 circular issued by the GST department, and that was in relation to donation. And then they have said, as because this circular exempting the donation to be exempt, and this notification doesn't apply to a grant. So they themselves brought out this circular, and that circular, though applicable only for donation and not for grant, and they have taken sight of this circular, and they are saying even through this circular, the applicant is not exempt from the applicability of GST. Hence, it can be concluded that the applicant in this particular case has failed in raising the argument in logical sequences, because here the applicant has raised first the exemption notification argument, not the first argument as it is not form part of consideration or not in the furtherance of business. And at the same time, the authority for advance ruling has passed the order without dealing with all the argument raised by the applicant. It is not a speaking order in that way, because even if there is no logical sequences, but the issues were raised by the applicant, and those issues, the advance ruling has not given a speaking order. So these are in short the observations, my observation on the advance ruling. And now I over to Sandeep for taking these proceedings further. Thank you very much.
Thank you. Thank you very much. Can you please close the presentation?
Sure.
Yes, thank you very much. Highly technical, and therefore it must have been difficult for participants to capture, the aspects of it. But I think beautifully explained in terms of what issues were there and what was lacking. But before I get into this analysis of this particular advanced ruling, for the benefit of the participants, I think it would make sense to delve a little bit more on the aspect of, so basically GST is levied on supply of goods and services in the course of furtherance of business. So what does supply constitute? What does consideration mean? And what does furtherance of business mean? If that can be explained in a brief, that would be extremely helpful. So any of the panelists, can you help in understanding this? What does supply, scope of supply, what does it include? Because I think that is the question that most of the participants are asking in the chat box. So before we move ahead with explaining this or analyzing this case particular ruling, I think that would be extremely helpful if that can be explained in a short, in a simple.
Suresh ji, you can just continue for 2-3 minutes.
Okay.
Actually, what does supply mean, Suresh ji? Very straightforward.
No, they are not defining supply. They are defining a scope of supply. Okay.
Scope of supply.
And they are saying a scope of supply shall be supply of goods and services through different forms, sale, barter, and 8-9 different forms for a consideration. That is, whenever there is a supply of goods services, it has to be for a consideration. And again, it has to be for and furtherance of furtherance of business. That means the scope of supply shall be only when it is a supply first. If there is no supply of services, then this will not go for consideration and the business argument. If there is an agreement for supply of services, then it has to be for a consideration, and it has to be for the furtherance of business. So I explained that in a voluntary contribution agreement, there is no condition to supply any service. It is in a corpus grant agreement, there is no condition for supply any services, and so that it comes not under any services supply agreement. But again, in a restricted grant agreement, whether the donor says that you have to perform this particular program, then it becomes a condition for supply of services. But the issue remains whether that constitutes consideration, whether that program will constitute furtherance of business or not. Okay. And that is the point we have to debate, because consideration has been defined separately under GST. It is not a common meaning we understand by consideration. Again, business has also been defined in a different way under GST. Because normal business we mean, it has to be with a profit motive. It has to be a frequency of transaction. All those has been taken away while defining business. They have said business means maybe for a profit or maybe for non-profit motive. Maybe a single transaction will constitute business. So all the Supreme Court judgment on the business under Income Tax Act, what are the basic ingredients of a business, has taken away through the definition of business.
Right. Thank you very much. So even though complicated, I think this helps the participants a lot in terms of understanding the basics of it. And I think now we shall move on to this particular advanced ruling that has come, and number of issues that emerges from the presentation that we have served and the ruling that has come. And here I would like to bring in Dr. Fogla. Dr. Fogla, in this advanced ruling, they have tried to distinguish between a grant and a donation. And they said that it is not applicable on donation, but applicable on grant. And specifically on this issue, I would like to ask that will a grant be treated as consideration against supply if the grant is not a donation, but for a specific charitable purpose? So if a grant is for a specific charitable purpose, will it be treated as a consideration?
No. Actually, if we understand this, because that is the most crucial part of the entire thing, and that is where this contentious ruling has come, because to our understanding, a grant is a transaction which is a trusteeship based transaction, a trusteeship based transaction is there and legal obligation is undertaken by somebody on behalf of somebody else. So when there is a legal obligation, it is outside the purview of fiscal activity on the part of the implementer. So it is not a fiscal activity of the implementer. So this is not a financial activity or economic activity of the person who is implementing. It is under trusteeship. Therefore, charitable organizations assessment even under income tax is not done as a legal entity. A Section 8 company is not assessed as a Section 8 company if it has 12A registration. A Section 8 company will be assessed as a trust. If it loses 12A registration, it will be assessed as a Section 8 company. So the question here is that what is the purpose of a donation? What is the purpose of the grant? If you see in our study material also on page 6, we have given a circular. It was issued by the Finance Ministry clarifying the applicability of GST, in which the circular it has said that for a grant or a donation to be exempt from GST, there's 3 conditions should be satisfied. One, it should be in the nature of donation or a gift. So now a donation or a gift been exempted, but donation and gift for self-consumption we are not talking. We are talking donation or gift for a philanthropic purpose. So that is the second condition, that the donation and gift should be for a philanthropic purpose and it should not entail any commercial gain on the part of the person who is giving the grant. And there should not be any advertisement value or publicity given to the donor. So these are the 3 conditions, and all these 3 conditions are fulfilled in a grant, and it is a trusteeship transaction. And that is why Supreme Court said that don't confuse between grant and a donation. If a fund has been given, and if the person who has received the fund and implementing that, if that person is duty bound to spend the entire amount on that particular philanthropic purpose, then it is a trusteeship contract. It is not a fiscal activity at the hands of the implementer. Therefore, to my understanding, a grant or a donation, if it is for a philanthropic purpose, if there is no advertisement value or publicity or any interest, direct or indirect benefit going back to the donor, and if that is unconditional for the purpose. What we are talking about the condition is that suppose there is a project, there is a flood or an earthquake type situation. The law is not said that the donor cannot sit with the partner organization to identify which are the most vulnerable villages where we should work. It could not be the intent of the law where the donor will not participate in identification of beneficiary. There should not be any vested interest of the donor in identification of beneficiaries. Then only it will have a character of GST contract. Otherwise, I don't think that it will make any difference whether it is a grant contract or a donation, a voluntary donation, as long as the donation it is for philanthropic purpose. The entire amount is subject to utilization. Unspent balance belongs to the donor, and there is no scope of profiting out of it. There is no invoicing. It is based on deliverables. I think GST will not apply.
Right. I think that's very clear, and the ruling seems to be quite myopic in that sense, to have distinguished grant and donation with a very limited interpretation.
I think Sandeep, here I think what Dr. Fogla is saying, in a way, the advance ruling is saying that grants are to be put under GST, isn't it?
Yes, that is what in the ruling it says, that the grant should be put under GST, but not donations.
Not donation.
Distinguished between donation and grant, and therefore my question was that whether giving grant, because there is an issue of consideration, therefore whether giving grant is considered as a consideration and GST will apply. And that is what Dr. Fogla said, that grant is not a consideration because it is a legal obligation on the part of the recipient, and therefore it is not, GST should not be applicable. And coming to this, similar issue again, is that they have again used that circular and excluded subsidy. So government subsidy is excluded from the definition of consideration. Does that mean grant is not excluded? So again, that is another question that I have for Dr. Fogla.
No, that is not under the transactions. Basically, try to understand the GST, this the scope of or the purview of the act starts only if there is an activity which is towards furtherance of business. So in the course of business, what could be a consideration? Consideration could be anything. Consideration could come from a third party. Consideration may not be given by the person who is benefiting out of it. These are the things that which creates the confusion that probably grant also would be treated as a consideration against the services rendered, because there are clear-cut services which are rendered and the organization has agreed to render those services, and because those services are rendered by the organization and the money has been received, so the money received is the grant amount and the services rendered is the services, and there is nothing in the GST Act. If you see the consideration or the supply, they seem to be wide enough to cover both grant under consideration and the services rendered under supply. But now the problem here is that here this subsidy word has been excluded in the sense that it is an enabling clause, because subsidy generally is given in context of a commercial transaction. Suppose there is a project cost of a factory, the cost will be 50 crore rupees and 20% of the cost is subsidized by the government or some other authority. Then the law says that the particular portion of the commercial transaction, that is the subsidy, will not be a part of the GST purview. But I don't think the consideration is there, because the other part is a clear-cut consideration, because if you are purchasing, selling something, and in that particular transaction there is a component of subsidy, and that particular component of subsidy in a commercial transaction would be out if it comes as a support from government. In that sense, even a subsidy has been included. Therefore, there is no reason why a legal obligation will be excluded. And if you see the circular issued in 2019, which says that any grant donation for a philanthropic purpose, how can be a donation, so that there has to be a purpose to the there has to be a grant and there should be no commercial intent, and the philanthropic purpose also they have defined that it should be without commercial intent. So they are not saying that in the philanthropic purpose, if you say that you go and work in village or together, let us identify the beneficiary, suddenly it becomes a commercial transaction. So to philanthropic purpose with commercial intent, that is what is being said. So to my understanding, the subsidy is an enabling clause, but that would not have any effect on it.
That would not have any effect. One question that I would like to ask, which is always in the minds of NGOs, and it is quite confusing, is with regard to TDS being deducted on grant amount. Many of these government contracts that NGOs receive, or for that matter, even in corporate grants that's under CSR granting system that NGOs receive, TDS is deducted. Will deduction of TDS attract GST?
No, you have to understand, when the advanced ruling authorities are direct taxing the normal grant contracts and we are getting rulings, so obviously TDS will create far more controversies, and at least at perception level, it looks like a commercial contract, because the onus shifts on the organization which has received the money, because if TDS is deducted, most likely it is deducted as a contractor's service or a professional service under section 194C or under section 194J. So the person who has given you grant is declaring that it is a commercial service. So when the person is declaring, then it becomes the onus is on you to establish that how it is a grant. So that way, TDS is not a very simple issue. But there are case laws, inadvertently sometimes TDS is deducted, and there are case laws where it has been said that deduction of TDS itself will not be the determining criteria to treat an organization to be a business activity or a commercial transaction. So that is what we can say, that the larger facts and circumstances of the transaction will what will finally determine the nature of the transaction. TDS will only add to the worry you have on your hand.
Okay, and therefore the advice should be to negotiate.
Negotiate. Normally, the terms like consultant, client, deduction of TDS, those things actually should be avoided. Maybe organizations, even if they are in this gray area, they are not very sure whether GST will apply or not apply, or for that matter, even if you are sure that GST will apply, but the law has not settled down, we have advanced ruling, AAR authorities saying that it is taxable. So you can say that many of the assessing officers in the country will start raising notices, and before you get rulings from the appellate advanced ruling authority or high court or tribunal, it is better to be careful and see that these kind of contracts are actually signed properly, or at least you sign this contract, or you may engage in such contracts in an activity which is not the principal organization, the principal charitable organization.
Right, I think the advice is pretty clear. Obviously, it leads to confusion the moment TDS is deducted. The other question that I wanted to ask you is that, there are different ways in which grant contract is signed between the donor and the recipient organization. Now, in case where will a grant be treated as a commercial transaction if the project is based on specific deliverable and not on actual utilization? So, for example, in a grant contract, it says that such and such work needs to be accomplished. And it is not defined by the utilization of fund, but based on the outcome or the deliverable, something which the social stock exchange also talks about this impact. The moment impact is created, then the issues around. So that is another thing that will come up maybe later on. But for now, there are several grant contracts like this, which is based on deliverables rather than actual utilization. Will these kind of contracts attract GST?
If a contract is based on deliverables, then such contract is not a trusteeship contract. Trusteeship contract is that some money is there and we are going to spend it. You don't have any responsibility. If you start taking responsibility, that means you are supplying services. You are saying that I will construct X number of sanitation washrooms, I will do X number of cataract operations, or I will create organic fields of 1000 acres, and per acre I will charge so much, or I will train X number of beneficiaries per beneficiary. So that is a clear-cut service. Even if you are not making profit in such contracts, even if you are not making profits in such contract, to my understanding, GST will apply. That is where the relevance of this definition of consideration, the consideration may come from somebody else. And a business, it may or may not have profit element. So it is not about that whether you make profit. In a business, you make losses also. So a charitable organization cannot say that because I did losses in this particular activity, that is why GST should not apply, because I did not make. The point is not whether you make profit or loss. The point is whether it is a genuine charitable activity, whether there is trusteeship. So if you say that I will do X activities and I will charge X amount, and I will not share what is the cost incurred against that, to my understanding, GST will apply on such contract.
Just to apply in such kinds of cases. Now, the other question, something which is partly related, is that many of these grant contracts that you sign, there are internal costs. Like, for example, there are staff costs or administrative expenses and so on. And some of the contracts allow or have a provision where you can charge on percentage basis part of the cost with organizational charges to that project. Will the nature of contract under GST change if the organization makes internal transfer? When you're charging, then you also make an internal transfer against administrative cost and services rendered. So, in such kind of an arrangement, will GST be applicable? Where there is management fee or administrative fee that you charge to a project, and there is internal transfer that happens.
No. On the face of it, such transactions are subject to, it looks that they are subject to GST, because when you are making an internal transfer, then actually there is no transfer. You are paying yourself.
Right.
When you pay yourself, the normal understanding is that such transaction, whether you will benefit out of it or not, that is not known. So once that is not known, these transactions become very gray and debatable in nature. But some time ago, there was a case in Karnataka High Court where, in context of a commercial organization, the organization in a government contract had made a bidding saying that we will use a particular type of machinery and the cost of the machinery will be 5,000 rupees per hour, and the bid amount and the cost was accordingly computed and the contract was awarded. But when the services were rendered, that organization has actually used its own machinery and transferred it to its own account, 5,000 rupees per hour. And the government and the authorities said that this is a violation of the contract. This money was supposed to be paid to external contractors, and it has been transferred to its own account. In this case, surprisingly, Karnataka High Court said that you have to see if there is a reasonable amount which has been transferred. Only because the machine is owned by the service provider, that doesn't mean that it is an illegal transaction or it is violated the law. So if it is a reasonable transfer which has been made, such transactions should also be considered as valid expenditure for the purposes of determination of GST or service tax. For income tax, it is a different issue. For income tax, internal transfer cannot be considered as expenditures. We have to go to the place where they were transferred and see whether actually some money was spent or not. So Income Tax Act, because Income Tax Act is an act where you determine the state of affairs for 1 year. So during that particular year, that money was spent or not, we have to see. But GST is a transaction amount, tax. At that particular point, whether it is taxable or not, that we have to see. So therefore, one is that internal transfers should be avoided, because it would be very difficult to give an interpretation that they are genuine expenditure, though there are judicial precedences in support of that. Secondly, internal transfers cannot be very artificial and exorbitant, because I come across contract where the organization charges per day against their employee. So suppose they charge 10,000 rupees per day for 10 days of the employee, but the employee is getting 40,000 rupees per month. So that cannot be more than what you are actually spending. So that way the onus will be on the organization to establish that this internal transfer was actually an actual charge which has been internally created, and there is no benefit arising out of it. So it is a controversial issue. I'm not suggesting that you should make management fee or internal charges, but this is the law surrounding it, and you should be careful about it.
Right. Now, the other issue that I would like to ask you is that, if
just before that, if Suresh ji, would you like to add something to this?
No, this was comprehensive. Only one point I can add here. If we charge internal charge to a contract, and that is a substantial part, then the entire grant agreement may be subject to GST, not only the portion we are charging as an internal charge. Because the Supreme Court apex ruling that the grant which gives some reward to the organization. So your entire grant agreements may come under the GST, not only the charge you are making through internal charge.
Right.
That's all.
Right. So I think that very important addition, very important point, that if in such cases the entire grant would be subject to GST and not that portion where it is charged. And in the Supreme Court ruling, it was discussed earlier that the basis determined was also whether anything above the consideration was provided. So in this case, it could be constituted as something of the consideration. So therefore, one needs to logically argue whether it is above the consideration or not. That is what Dr. Fogla is trying to point out, and says it is a very complex issue, and there needs to be abundant caution around that. Now, in some cases, the donor provides a grant with the condition that the grant money should be utilized for the benefit of the poor employees of the donor. So, there could be numerous examples around that. A charity arm of a corporate, let's say of a textile company, and then they say that you use this money for the benefit of the workers who work in this textile factory. Will that be subject to GST, Dr. Fogla?
And there could be various donor-related conditions. Maybe Suresh, briefly you can touch upon the kind of issues which may arise. Then maybe I can try to sum it up.
So far as GST is concerned, it is mandated by the or direction by the donor to give to which category of beneficiary. That means beneficiary is identified by the donor. And what support the organization has to give. If these are linked with the grant, that means grant is linked with the beneficiary and grant is also linked with the benefits to be given to the beneficiary, then I think it will constitute satisfy the test of consideration. Though it may have this type of agreement may have its implication under income tax, because here the company benefit is also going to the donor because their employees are being benefited. So we are not dealing with that income tax issue, but under GST, that will constitute chargeable or taxable event if that services doesn't fall within the exempt supply.
Right. Dr. Fogla, would you like to? Okay, I think so. The issue is that, in such cases where the beneficiaries are already identified.
No, Sandeep, just to add to what Suresh ji is saying.
Yes, please go ahead.
That now your question was that if the donor says that if it goes to the employees.
Employees of that company.
So employees cannot be treated as beneficiaries because beneficiaries should come from public at large. So if the donor says that my beneficiaries, even if they are otherwise poor, I don't think under Section 215 of Income Tax Act, they can be treated. And in any case, that money has been, so even the donor probably cannot claim it as a CSR expenditure. And the organization also should not give ATG benefit to the donor who is asking the money should be sent back to the thing. So it is not a question of whether GST or not, because actually it is a fiscal transaction. So basically no services are rendered and the money is just being rotated through the account of the charitable organization. So basically, I don't see any services or supply rendered in this account as far as giving money to the employees is concerned.
Right.
But what we should see that suppose a donor participates in identifications of beneficiary. There is nothing in the law because obviously all charity contracts are partnership contracts. So if you are partnering and with all genuine interest, you are identifying the best possible. So there is, we cannot say that the donor is deprived of sharing its knowledge or expertise in identification or implementing of the program. If the donor has some expertise to share, the donor can always share. It could be identification of beneficiary, it could be technical know-how, it could be volunteering, it could be providing some other infrastructure. So there is nothing wrong in donor participating in a program. So only because the donor participated in the identification of beneficiary per se will not result, but the donor should not have a vested interest. So the donor is selling, say, fertilizer, and the donor is saying that you distribute this particular seed in the farmers of this particular area, and where the donor is dominantly selling fertilizers. So you have to be careful whether the donor has a direct or indirect interest in identification of beneficiary. Even a little bit of interest is identified or found, then such contract will attract GST. But normal partnership related decisions, I don't think GST will apply.
Let me ask a very practical question regarding this particular issue. For example, a corporate has a factory area in some rural setting, and they ask this NGO to work in and around those factory areas and give a grant. Will such contract attract GST or not?
Now, this again is a question, because in the past also developing infrastructure around the factory has been treated as business expenditure before the enactment of CSR law. So sanitation, water, benefit, etc. So these kind of things, I think, will attract GST. Of course, there will be arguments, and we have to see the exact facts and circumstances, because the donor also is obligated under CSR to work in its local area. So that way it will depend on the facts and circumstances, but immediate vicinity of the factory, etc. If these are conditions, then the onus will be on the charity and the donor to establish that these were totally arm's length decision and there was no business interest involved. So these are gray areas. It will depend. So we need to understand the principle. I don't think we can give answers.
Right. In the advance, now moving ahead with the next question, in the advanced ruling that has come in this particular case, this Maharashtra Authority for Advanced Ruling, as well as some of the other advanced ruling in the past, we have seen that in the primary determinant factor that has been considered is the charitable activity, and they have taken the earlier service tax notification as to what constitutes charitable activity. Our interpretation, our logic has been whether it is in course of furtherance of business or not. So that has been the determining factor as far as our analysis is concerned, or particularly your analysis is concerned, to be considered whether GST applies or not. Now, I would like to ask you, for the benefit of the participants, so when an NGO can be considered to be engaged in furtherance of business, when would you consider? Because your argument in most of these cases, you're arguing that because it is not in course of furtherance of business, therefore GST is not applicable. So when would you say that NGOs could be considered to be engaged in course of furtherance of business? What are those areas?
To begin with the simple statement that when the NGO is doing business, it will be considered to be engaged in business. Because now the NGO is registered under an oath in some sense before the regulatory authority where it gets the registration, that each money, each rupee, corpus, income is irrevocably set aside for public charitable purposes. Nobody, no general members, no board members will ever have any benefit out of it. And if the NGO is able to sustain those conditions before all other authorities, whether income tax, the registering authorities, then there is no reason for the NGO to believe that it is engaged in any kind of business. Now the issue is that if in the execution of the primary services, if it is accepting money, can it be treated as a commercial activity? So now that is where the GST law, there are so many complications which have arisen because the way the law has been structured. For instance, to my mind, GST, as per Supreme Court ruling, educational institutions, medical institutions, even if they charge to their students, they are out of purview of the GST because it is a charitable activity, even if reasonable money is charged. But under the GST law, we treat them as taxable activity, and under a notification, we take exemption. So we don't treat them as exempt activities outside the purview of, but we are comfortable. We are comfortable as long as we are getting the benefit. But why we got the benefit? That is where the challenge comes. That is where the challenge comes. That what is a business activity? Educational institution is exempt from GST because there is a notification. If the notification was not there, it will be considered as a business activity. That itself is a contentious thing. But some court of law at some point of time will determine that per se a medical activity or educational activity, if the organization is otherwise claiming its charitable status, FCRA, income tax, regulatory authority are not finding any problem with the organization the way it is functioning, and it is following all the rules applicable to a charity. No money is distributed to anybody. It is not a business. But the GST law has been structured in such a way that most of the exemptions which currently are being enjoyed are enjoyed through notification, which otherwise means that these are business activities and nobody has challenged that. And therefore, any interpretation we make, which will be a radical interpretation, and it will be subject to the test of legal scrutiny, which will come. It is going to come very fast in a year or two, because GST is already 4 years old. Now we have plethora of judgments from this various advanced ruling and tribunal, and very soon we will be having a lot of High Court decisions. But for the purposes of our discussion today, we can say that an NGO will be, from a GST purposes, an NGO will not be treated as a business as long as it is implementing and applying money received from the donor entirely for the purposes for which it is received. An NGO will be treated as doing to be business for the purposes of GST if it is engaging in any incidental business which it is doing. And an NGO, this is the gray area, the three broad category I said. One, applying the money for the donor. If it is delivery based, GST will apply. If it is utilization based, GST will not apply. To incidental activity based on GST law, whether you are selling medicines, you are selling clothes, you are renting out properties. So there are various sub laws based on that. These are taxable activities. Third group of activities is that where the NGO is charging its beneficiaries. So NGOs, colleges charge their beneficiaries. Sometimes NGOs subsidize their beneficiary. To my mind, these are not business activities. If you are subsidizing, if you are collecting 100 rupees from a beneficiary where the training cost is 1,000 rupees or 10,000 rupees, it is not a business activity and it cannot be treated as furtherance of business. But the problem is that the GST law has been structured in such a way where the notifications, to my mind, are not consistent with the intent of section 217, which defines furtherance of business. And therefore, any NGO charging its beneficiary may be subject to GST based on the current practices, the way GST consultants and authorities both are opining. So that is where one has to take a conservative view of GST. Maybe if you challenge it, to my understanding, you have a good chance that you can establish that it is outside the purview of GST.
Right. I think that was a very comprehensive explanation. Now coming back to the charitable part of it. In this 2017 notification on exempted charitable activity, as you know, it is very narrow. So does that mean that all other charitable activity are subject to GST? Because the charitable activity as defined in this 2017 notification is very narrow. But charitable purpose under income tax is something entirely different or much broader.
No, look, the 2017 notification is talking about charitable activity. It is not talking about charitable purpose, because under income tax, FCRA, we talk about purpose.
Right.
FCRA, we saw that money received with a definite purpose. And income tax is also for a definite purpose. Here, because GST is a transaction-based tax, so that means specific activities, even if done as a charitable organization, specific activities, if otherwise are towards furtherance of business, if specific activities which are towards furtherance of business, even such activity will be exempted for those organizations which fall or which are exempted under the notification under 2017. Suppose an NGO which is counseling a patient of HIV/AIDS or the other terminally ill patient who have been exempted, and even if he is charging a patient amount for that particular charitable activity, if it is a charitable activity, even after charging the beneficiary, it will not fall under GST. That is the meaning of that notification. It doesn't mean that genuine charitable activity will be taxed.
Right. I think this explanation is very helpful, because that is what is confusing most of the NGOs all the time, is that exemption has only been provided to the specific set of activities. So you distinguish between purpose and activity. So I think that was very helpful to understand that it is only in such case that the exemption is for those particular activity that has been mentioned. The other question I wanted to ask, and I also saw it in the chat box, some participants have raised it, is with regard to the project contract. In the project contract, the unspent balance is not required to be returned back to the donor. There are many such contracts you would see that the donor would not want the money to be refunded, unspent balance to be refunded. Will GST apply in such cases?
No. If there is a possibility of an unspent balance in a contract, that means that contract is not subject to 100% utilization. And such contracts will be hit by that Applicability ruling Supreme Court, which was discussed in the advance ruling. So I don't think you can have a charity contract where you can generate unspent balance. If for some reason money is not spent, then the money should belong to the donor. And even after approval of donor, if you are getting surpluses unconditional, it is not a very advisable thing. So I think unspent balance, there should be clarity in the contract regarding unspent balance, and there should not be any possibility of an surplus in the project, because if there is an unspent balance, that means you could not apply the fund as per the approved budget, or there was no approved budget. So I think you should avoid those kind of circumstances.
Right. I think I'm done with the issues that has come out of this advanced ruling. The final question that I would ask from my end, and then I would look into some of the questions that the participants have raised. And for the benefit of the participant, I think this needs to be answered clearly, whether this advanced ruling applies to NGOs all over India.
No, it is provided in the GST Act itself that advance ruling will apply specifically to that particular organization. It is a view or a recommendation given to that particular organization, which has applied to clarify its doubt regarding the applicability of law. So advance ruling, I don't think can be treated as a law for the country. But of course, the assessing officer, etc., may follow it, may try to apply the same principles at other places, but legally it does not apply.
Legally, it does not apply, and I think that's a bit of a relief to the NGOs for the moment, at least. There are some questions that have come in the chat box, and I would like to ask them. I guess most of them has been, already covered. So allow me to look into it and ask you. If NGO receive funds for education or benefit of specific child through an agreement, this sponsorship program, child sponsorship program, will that be subject to GST? Suresh?
Yes.
Again, the principles remains whether this constitute business, furtherance of business. Though it may constitute some element of consideration when they are specifying that this particular child to be benefited. So the consideration element may come. But again, the issue of furtherance of business, or we have to see whether exempt notification comes or not. So exempt notification, I also don't understand whether I feel that it will not come under exempt notification. So only space I find is furtherance of business here.
Whether it is for furtherance of business or not.
Or not, this will be issue on a debate for this.
Even the child is identified.
The child is identified. So some element, because so far advanced ruling, if we go by conservative principle, so far advanced ruling has given the consideration a different meaning. And they are saying when there is a linkage of the grant amount with the services and the donor and the beneficiary, then they are clear that is a consideration. But they have not given any opinion on the business, furtherance of business.
Business part, right?
Yeah, yeah.
So they say if the nexus is established, then it is consideration.
Yeah.
But they have not considered furtherance of business.
No, this is furtherance of business is a gray area, still not considered.
Right. The other question, that has come up from the participant is that research grant, for example, receiving a research grant from, let's say, government or any other entities, will it attract GST?
If the research is sent back to the government or the donor, it will definitely, it is a benefit to the donor. It is so it will result, it again passes the test of consideration.
And in such cases, GST will apply.
Yeah,
But
the consideration test apply. Consideration test is satisfied.
yeah, but the issue is that if an organization is a charitable organization existing only for research purposes, and if the donor is supporting, because you have section 35 in the Income Tax Act where scientific and research organizations actually are the blue-eyed boys of the government, where you have 150% deduction, 175% deductions. Maybe the IITs, the IIMs and various organizations do research for the benefit of the society at large. So I don't think a research grant itself is subject to GST. But if the research contract is awarded where the donor itself is a research institution, or the donor requires the inputs from a research for its business or some other purpose, in those circumstances, the research contract will be a GST contract, but a contract to a research organization or a support organization for conducting certain research which will help the country at large should be treated just like a charity contract.
Right. So it depends. That's what you're saying. Yeah, so many of these questions are quite similar, and I think we have been covered. Like, for example, one question is that CSR grant has been received from HSBC for skilling 200 youth under skill development program. Will GST be attracted?
So now the issue is that we are not privy to the HSBC contract. So now we give an opinion here, then somebody, it will be a half-baked thing, but we can say the same principle that HSBC is supporting 200 youths, and HSBC is, if not directly or indirectly related or benefiting out of this youth, because sometimes you are supporting the youth, the same youths are hired as training in the organization or interns in the organizations, and all those things are also there. So there is a possibility that it could be treated as GST, but such contract in general should be out of GST if they are subject to 100% utilization.
Right. I think this one you answered also while you were answering to my questions, but still it has come. If an NGO is charging nominal fee from participants, let's say you organize a workshop and you charge nominal fee from the participants, will it be considered as a service being offered and come under definition of consideration?
No, as I said, that whenever there is a charge to participants, all such activities are exempted through notifications. For instance, you educational courses, so that there are notifications that primary school education is exempted. Why should you need a notification to say primary school is exempted? It is charitable activity. It is outside the scope of GST. So it should not have been a part of the notification. But this is how the law has been structured. This is how we have accepted it. So in that sense, charging beneficiary is a contentious area, and therefore many of the consultants advise that better to make it a GST receipt. But though I am of the firm opinion that these are charitable activities and they are not under the scope of GST. But this is a highly technical matter, and we don't have the authority. We can only opine. Some court of law someday has to decide, or the government has to give clarification. Right. You talked about the deliverable issue in a grant contract, and there is also a question regarding that, because most of the grant contract, the indicators are defined, and there is a budget which is based on actuals. So if the deliverable is defined, do you mean to say GST will attract even if the expenses is on actual basis and there is no consideration beyond the actual expenses that is paid to the organization? Because this grant contract, obviously donor would want to know what ultimately you will achieve. The world talks about impact, so obviously the project contract want to see what kind of impact this project is going to create. But there is a budget and it is on actual basis only. Will GST apply if the deliverable is defined? I don't think anything which enhances the effectiveness of the program, it brings more efficiency, transparency to the program. It makes the implementer more accountable, and it is subject to 100% utilization. If it is subject to 100% utilization, then this trusteeship element is satisfied. Because the problem here is that we think that if somebody has received the grant, then we see that that person or the organization has received some benefit. We have that mindset. We have that kind of mindset because we find it difficult to believe that a person without any personal interest will do something for somebody. If NGO is taking some grant, so that this NGO, the office bearer must be having some interest. वो कुछ ना कुछ करता होगा, नहीं तो क्यों लेता है grant का contract? So because we have that kind of mindset, that is why we think that it is a service. Because if I remember, Swami Vivekananda was given a donation and he did not thank that person. So he said that the person for whom I have accepted the donation, he should be thankful. I am taking the responsibility. because it will create a hell lot of problem at my end if I take the money and I have to utilize it. So we have lost that spirit and that mindset. That is why we think that if the money has come, so that is the spirit in which NGOs work, and there is nothing in the GST law which take away that spirit. So if you are a trustee and if you are genuinely try to understand, NGOs are also being run by seriously dedicated organizations where the people have dedicated their total life, and the entire money is used for the charitable purposes, not a single. So if the trusteeship is being followed, I don't think there is any law in the country which can declare that it is a business activity. And there is nothing in the GST Act to suggest that a pure trusteeship, 100% utilization based charitable work can be treated as business activity. I read again and again the GST Act. I don't see anything of that nature.
Right. So one question that has come is this: construction of school building against donation received, will it be considered under GST? You received a grant and constructed a school for education purposes of the poor beneficiary.
No, but in your question there is an answer, because in the question what I understand, the donor did not ask you to construct the building. That means it was a donation. Yes. So donation in any case is exempted. Even the advance ruling is saying that it is out of GST.
Yeah, but if it is a grant and as part of the grant the requirement is to construct a school,
that also is fine if the entire money is for that particular educational activity.
And the one question is, in this COVID times, if the donor asks an NGO to distribute PPE kits, and so NGO purchases PPE kits from vendors and distributes kits to recommended beneficiary, will this be subject to GST?
So now, why should the donor recommend beneficiaries? The donor may have some expertise. Then together they can identify the most vulnerable and the most deserving beneficiary. So if it is being honestly done, otherwise this is contracts where the donor is saying that I am giving a list of 20 beneficiaries, you go and give them PP kit. So then you are helping donor for some private purpose the donor wants to achieve. So I think GST will apply if the donor recommends the beneficiaries. Donor cannot recommend beneficiaries. Donor may play a co-trusteeship role. Try to understand that donor also becomes the trustee. When you register a trust, the settler also becomes the trustee. And to the extent of trust property, the settler is not the owner of that money. So the donor can become trustee of its own money. Nobody is stopping it, but he should be a trustee. He cannot be the owner of that money and say that I do this, do that. So if he's saying do this and do that, then GST will apply.
Right. Now this around that internal transfer or internal billing that we talked about. So there is a confusion, it seems, with regard to admin cost. And the question is that what if the agreement between the donor and NGO include the admin cost? I think that needs to be clarified, whether it means that admin cost cannot be charged to a project.
No, admin, all expenditure, even high or low admin cost, there is nothing in the GST law to say that admin cost will be 10% or 20%. Whatever genuine expenditure. So there is no, so admin cost, we are talking about actual expenditure and notional expenditure.
Right.
And if it is a notional expenditure, then also there are some judicial precedents which I have already discussed.
Right.
Actual expenditure in any case is allowed.
In any case, it is allowed. We are talking about the beyond the the actuals. That is what Dr. Fogla was mentioning the last. Suppose grant from overseas donor attract GST. Will it constitute to be export of service where GST is nil?
No, if the grant amount received from overseas is subject to GST, then there could be two possibilities. One, it is an export of service. Two, you are doing some activity on behalf of the donor in India. That means the donor should have a branch office status and approved status from under FEMA from RBI. Donor doesn't have any right to do any activity in India.
Right.
Donor cannot execute any contract in India. Donor can only award a trusteeship to a FC registered organization to do activity in India. So if it is a commercial contract, then either it may or may not be export of services. You don't know, cannot take it for granted. Some organizations may do this intelligent planning, that let us say that it is GST and don't pay GST because it is export of service. That may not work.
Right. One of the questions that comes most of the time when we talk about GST, earlier service tax, now GST, is about this usage of donors' logo and branding in the event banners or posters and so on. So if there is a clause in the agreement which says that donor logos needs to be published or mentioned in all the paraphernalia that is associated with conducting of any program, will such grant contract or a CSR contract attract GST?
Yes, they will attract GST if the donor says. And if the donor is not saying anything, and if the organization is also going overboard, and it is publicizing the donor more than what could normally, in the CBTD circular, they have given examples also. What should you write? Created out of magnanimous support from Mr. So-and-so. Somewhere you can write before a building. But if you put a LED light on the building saying that Mr. So-and-so is the donor, etc. So even if the organization goes overboard and in a humble way, it is acknowledging the donor, that is all what is permitted. Rest, any kind of publicity, I think, will attract GST.
Right, thank you. Thank you for that. I think we have covered most of the questions that are there that have come from the participants. Most of the questions are common, so therefore I've not taken up each one of them, but I've generally asked the areas that you wanted to be covered. But if there is anything specific, Dr. Patra, would you like to take up from the questions that has come up? Because I don't see any.
No, I saw that most of them have been covered, both through the question and answer and later on by what you have given. So mostly, I think the top lines have been all covered. And probably what we can also do is that we could create a compendium of all the questions and the answers that have been given at a later stage, which would be helpful for organizations. But I think these are all generic. So basically, if there are any specific issues, I think that we need to consider it specifically and go into the details of it. Based on what discussions and questions, answers have been given, I'm sure the participants are wise enough not to appropriate it to their own circumstances, which might be very different. So these are all generic medicines. Please take it. But if you have certain very specific issues to be discussed, please get back on this. Thank you.
Right, I think so. We've covered most of the questions, unless Dr. Fogla or Mr. Kejriwal has to say anything more on the issue. I would like to.
Actually, just to conclude, I would like to say that this applicability of GST is very, very complicated. And whenever an issue has come up to us, we are examining from one point of view, or we are leaving other points. So until unless this furtherance of business issue has clarified, examining a particular transaction to come under GST or not is always become a debatable issue. So I think the law has to, because they have considered religious activity to be a business, and then they have given the exemption notification. So this furtherance of business issue needs to be settled.
Right, I think that's the saving grace as far as NGO's interpretation of GST applicability is concerned, and that is where we've been trying to rally on that, whether it is for furtherance of business or not. That's an important area which let us hope, as Dr. Fogla was mentioning, that 4 years has passed, so some kind of definite ruling, some kind of definite legal opinion should emerge from the judiciary. So if that is it, I would like to close this webinar for now, and would like to thank all the participants for actively participating, listening. A lot of questions have come, and I'm sure with the expert group that we had today, most of your doubts must have been clarified, and you've been benefited out of this webinar. Please watch out for such webinars in the future also. FMSF organizes such kind of important webinars as and when there is a need emerging in the sector. The sector needs to be informed, and we are always in the forefront in terms of doing that, and we would continue to do it in future also. You all are part of our database, and you will continue to receive such informations of webinars or any legal update that might come up in near future. Would also like to thank our team, our panelist, Dr. Manoj Fogla, for his clarity as always, be it FCRA, income tax or GST. Dr. Fogla is the go-to person as far as non-profit laws are concerned, and is once again very well articulated, clarified issues. Mr. Kejriwal for the presentation, very complex, very difficult, I can understand, but very presented very clearly in terms of how it applies. And Dr. Patra and myself, we are part of FMSF team. So thank you, all of you once again, and I would like to close this webinar now. Thank you and goodbye.
Thank you.